Appeals Division 1 is now in session.
Thank you.
Thank you all. Please be seated. This is a time set for oral argument in our case number CV22 0463, John N.D. Doe versus the Roman Catholic Church of the Diocese of Phoenix et al. Each side is allocated 20 minutes for argument. Appellant whose counsel is appearing by phone by leave of court may reserve a portion of that time for rebuttal. Mr. Abney, if you wish to do so, you'll need to keep track of your own time. We do have the podium clock here in the court, but that will help you comparatively less. But we will help remind you if things are going long. Out of respect for counsel and to avoid any embarrassment, I would ask those in attendance to make sure your phones are off so our proceedings aren't being interrupted. We've reviewed the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present oral argument today. Our proceedings are being recorded and will be posted to YouTube. As you begin your argument, please state your name and the party that you represent. With that, Mr. Abney, you may proceed.
Thank you, Your Honor. I want to thank the panel for allowing me to appear telephonically. As I was going over these materials again, it occurred to me very strongly that Section 3C of the Arizona Session Laws 2019, Chapter 259, which goes with the enactment of ARS Section 12.514, is actually a protection for the employer because the non-perpetrator employer is not going to be held liable unless that non-perpetrator employer knew or had actual notice of any misconduct that was creating an unreasonable risk of sexual conduct or sexual contact with a minor by an employee, a volunteer, representative, or an agent of that employer. So the legislature was not making non-perpetrator employers automatically liable when years later it comes to light that one of the employees has committed this kind of misconduct. It's only when there is knowledge or actual notice of that sort of environment, that dangerous, any misconduct environment, that the non-perpetrator employer is going to be held liable. I understand there's a disagreement about what the language means, but that seems to be a reasonable, fair interpretation that protects employers and allows the victim of this sort of sexual misconduct to have an opportunity years later to try to come forward and find justice for what happened.
So, this is good how. So if the church had notice of such activity happening in general, but not specifically with Father Hand, should your complaint be dismissed?
The complaint should not be dismissed for two reasons. The one is that there was knowledge at that time period when this misconduct was occurring with John N.D. Doe that there was this sort of misconduct going on when Father Hand was abusing that child. But there were also specific allegations in the complaint against Father Hand that he had committed that misconduct, and it was known that he was committing that sort of misconduct at the time, and that's in the first admitted complaint, IR 024, at several points, and specifically in paragraphs 91, 108, 111 to 112, 115, and 116. So there were specific allegations that they knew about Father Hand at the time.
So
there were also allegations of any misconduct knowledge as well.
So, does that mean that we need not reach the larger question then of the differing statutory interpretations?
You need not. you can decide this based on the plain notice that was provided in the complaint about specific misconduct that was known, that they had knowledge of. But this is, of course, this is a broader problem. There have been a number of these lawsuits that have come up, a great deal of confusion about what the language means. So if the court were to reach the broader issue, I think that would be doing a good service for lawyers and litigants across Arizona and for judges, of course.
But we don't like to address issues that we don't have to.
Yes, I understand, Your Honor. And as always, if you're willing to, if you want to decide this on the narrow grounds, you can. Certainly, that makes good jurisprudential sense.
Thank you.
Thank you, Your Honor. There were all kinds of subsidiary arguments that came up, and I'm not quite sure which ones the court would like to address or needs to address. There was some discussion about vicarious liability, whether it's properly alleged or whatnot. The whole structure of the complaint was that the society, the church, and St. Mark's were liable because of what their agent had done. That's vicarious liability. The only way they can act is going to be through their agents. They can't act in any other way.
So did you allege vicarious liability below, or is this the first time that you raised this on appeal?
No, I believe it was. I believe it was alleged in the complaint. It may not have been in that precise magical language, but the whole structure of the complaint, the thrust of it was that there is liability here because of what this employee did, and that is vicarious liability. There were also allegations of inadequate screening, hiring, supervising, and whatnot. So there were also direct allegations. But I believe that this statute is really set up and structured to be a kind of vicarious liability statute. That would explain subsection C when it's talking about the non-perpetrator being liable when you have this knowledge. I don't think there would be any need to do that unless the thrust of the statute was really to say that there is going to be vicarious liability under certain defined conditions against non-perpetrator employers.
Counsel, let me ask you, looking at the first amended complaint, there are 5 counts by my, 5 counts. 2, 3, 4, and 5 appear to be direct liability counts. Is it your position that the vicarious liability is in count 1?
It's my position that the allegations of vicarious liability are throughout the complaint and the very structure of the complaint. But I'm going back now to Jesus' own complaint. Hold on a second, Your Honor.
Of course.
Yes, the main count for vicarious liability would be count 1, but I believe that there's allegations that are scattered throughout there that really make this, constitute this as being a vicarious liability claim.
And I understand your argument, and certainly I understand the 133 paragraphs that precede the counts, but where in count 1 would we best find the vicarious liability claim?
All right. I'll leave that up again, Your Honor. I don't know, 135, 136, 137. The duties of reasonable care. I think they would overlap, and then you would go into the relationship established in 141 and discussed in 141 and 142. I believe that the thrust of all this is that there is vicarious liability as well as specific liability.
Well, help me understand how vicarious liability would mesh with your interpretation of the statute, that it can be any employee and not necessarily the perpetrator. You're saying there's vicarious liability if there was an employee, it's a national organization, an employee in some other state engaged in misconduct, they had knowledge of misconduct by somebody in Tennessee. There's now vicarious liability for the acts of a perpetrator in Phoenix.
I do not think it goes that right. That I believe that what's intended here by the language and the context of the statute is there's going to be any misconduct that would be affecting this particular minor. Putting that particular minor in an environment that is where there is this sort of misconduct going on. That would be the trigger and the protection for the employer that there's not going to be liability unless there has been this sexual conduct and sexual contact in an environment where there is this sort of misconduct that's going on.
Right, but my question though is there's that same environment, but it's in Tennessee, and there's no allegations of any misconduct by any employee in Arizona. You're saying that Arizona legislature intended vicarious liability to apply when there was conduct in Tennessee that put minors at risk for there was sexual misconduct.
I don't think so, because if you take a look at D, you're talking about sexual conduct or sexual conduct that would be time barred otherwise under Arizona statutes. I think you're talking about things that would have to be actionable in Arizona. So the focus from the context of the statute would be on any misconduct that would be addressable by Arizona criminal law. And I don't think that would apply in Tennessee or in any other jurisdiction. I think that the idea here was to confine this to Arizona and the reach of the Arizona criminal statute to deal with sexual misconduct of this nature.
Given that on this floor, all of your claims are direct claims, do we need to reach the issue of vicarious liability?
No, you do not. Once again, only if the court wants to reach out and provide a little bit of guidance. But I understand the reluctance to do that, and certainly I'm not going to argue for something that would be unwise in a broader sense as far as making the law clear and proper. But this keeps coming up over and over in these cases. What is meant by the particular language here? I don't know if the court would be willing to address that in a semi-advisory way, but it's a problem. I think the interpretation I proffered is a rational and reasonable one that protects the employers and then also provides an adequate remedy, the adequate remedy, I believe, that the legislature intended for the victims. So much of the problem with these kinds of cases is that it happened a long time ago. And this is somewhat of a guarantee that even though it happened a long time ago, it's not going to be a surprising liability on the part of entities such as the Society, St. Mark, and the Church, because they knew before, during the time of this particular molestation, and before, that there was conduct. There was systemic, endemic misconduct of this kind. And it's therefore proper to hold them liable if one of these victims manages to get a lawsuit filed within the time limit of the revival statute in seeking to hold the perpetrator liable and also to hold the society, the church, and St. Mark liable for what happened. There were some arguments that there can't be liability because the agent was doing something that was illegal or wrong. I believe that a reasonable interpretation of the Shallot case is that there can be liability even when somebody is doing things that are obviously crimes. It was rape and other forms of sexual assault in the Shallot case. But the Supreme Court says, well, there's going to be liability here even if you're acting to satisfy your apparent desires. Because what you're doing in the context of your employment, and in part because you are aided in committing that sport by the existence of that employment relationship. So there's still liability, even though we're dealing with intentional crimes, intentional wrongs under Shallot and under cases that have followed that. I think I've really made my main point. I'm happy to address any questions of the board on any point.
We have none at this time, Mr. Abney. You have, just by our clock, 5 minutes and 52 seconds for rebuttal if you choose to wish that. Thank you. Let me look to counsel for appellees, and I know we have 3 appellees, I think kind of in 2 groups, but I'll be happy to be educated by counsel.
Thank you, Your Honor.
Good morning, and thank you again, Your Honor. John Gray with Louis Roca for defendants appellees, the Roman Catholic Church of the Diocese of Phoenix and St. Mark Roman Catholic Parish, Phoenix, which I will collectively refer to as the diocese defendants. Your Honors, I would like to reserve and allocate roughly 4 to 5 minutes of my time for Mr. Fleischman to argue on behalf of his client, the Society of the Divine Savior USA Province, also known as the Salvatorians. For my portion of the argument, Your Honors, I will focus on the 2 primary reasons why the Superior Court's judgment below should be affirmed. First, the only issue for review identified in Appellant John N.D. Doe's opening brief is whether, under the window legislation, defendants are, quote, vicariously liable for the sexual abuse committed by one of their agents, employees, and priests against John N.D. Doe while he was a minor. But vicarious liability was not briefed below and has nothing to do with those claims in the First Amendment complaint or the Superior Court's decision dismissing those claims. As a result, Doe's appeal, which is expressly limited to that single issue, should be rejected out of hand. Second, if this court is nonetheless inclined to review the Superior Court's decision on its actual substance, it will see that the Superior Court was exactly correct. On the face of his own First Amendment complaint, Doe's claims are more than 40 years old, have been barred by the applicable statute of limitations for decades, and it was therefore Doe's burden to plead facts, not legal conclusions, but facts sufficient to avoid that limitations defense. However, Doe did not allege any such facts. Indeed, as the Superior Court correctly explained, the complaint is, quote, devoid of any facts supporting the idea that the defendants knew or had actual notice that Father Hen posed an unreasonable risk to children before 1978 to 1980.
What about paragraph 108? Why isn't that enough?
It's not enough, Your Honor, because it's a conclusion. It simply attempts to parrot the language of the window legislation, but it doesn't even do that. It's written in the disjunctive in a way that alleges that defendants knew or should have known that Father Hen posed an unreasonable risk.
Well, let's say they hadn't used or should have known. If they just said defendants knew, had actual notice, are you saying that's not enough?
I still don't think that's enough, Your Honor, because they simply describe misconduct generally, and they know how to plead facts rather than legal conclusions. If you look to any number of other paragraphs in the complaint, including paragraphs 50 through 54, where they talk about a different priest at a later time.
Well, that's because there are facts that are known. Maybe there's criminal complaints. Here, why isn't this something that would be resolved on summary judgment if they're unable to? If you file a motion for summary judgment and they're unable to come up with anything, why wouldn't it be more proper to resolve it at that point?
Well, again, Your Honor, the Supreme Court has told us that legal conclusions are not enough, and I still think that paragraph 108 only announces legal conclusions, but also if we look to the language of the window legislation, as Mr. Abney did, subsection C revives a cause of action and allows it to be brought. It doesn't say it allows it to be established or proven at trial. It says to be brought against a person who is not the perpetrator of the sexual conduct or sexual contact, only if, quote, that person knew or otherwise had actual notice of any misconduct that creates an unreasonable risk. And so this is a statute that talks about when a claim can be brought, not when it can be proved or when it's subject to summary judgment, but when this can be brought. And so I think we have to look to that language, and we have to look to the underlying causes of action that were revived by this statute. So again, we need to look to the context in which the legislature passed this. And
But does the legislature expect the plaintiff to know that there's something in a priest's personnel file? Would they? Let's say there's something in there that says this person has committed misconduct, has engaged in misconduct 5 times in the last year. Wouldn't there be a period of discovery to find that out? And why isn't this adequate as notice pleading, and then you do some discovery and find out if your factual allegation is supported by evidence?
So I think there's a couple questions in there, Your Honor. This isn't sufficient under notice pleading because the claim is barred on the face of the complaint by the statute of limitations. So then the burden is on the plaintiff again to allege facts to overcome that. And then with respect to the other portion of your question about is it reasonable to expect that the plaintiff would know what's in the personnel file or other material that could have been discovered, I think yes, absolutely it is, because these claims are 40 years old, as Mr. Abney said. Discovery is not going to reveal anything new, and the legislature...
But how is the plaintiff supposed to know what's in the personnel file?
Because the legislature passed the window legislation in the context of 40 years of existing litigation and criminal trials and all of the news that had been coming out for really at least 20 years on these matters. And again, plaintiff is able to point to other priests for exactly that reason. So those are the priests and those are the claims that the legislature is intending to revive here. And that makes sense because if this is a statute that revives any claim just on the fact that somebody may have committed misconduct in the past, well, then we're opening up these claims to be broader than the claims against the perpetrator themselves. And we touched on this in our briefing where the legislature has created an express distinction between claims against the abusers themselves, which are revived without caveat, without qualification for this period of time that was opened by the window legislation. But the claims against non-abuser third parties, anybody other than the abuser, are not revived without qualification or caveat.
But wouldn't there already be a little bit of a limitation? You presumably wouldn't have a claim for negligent hiring. There are claims that might not be there. If the legislation seems to suggest that only claim that you only get it if you had knowledge or direct knowledge. You don't have a claim for, and assuming maybe it doesn't cover vicarious liability, wouldn't there be there would still be a restriction, but that still doesn't mean that you're not entitled to any discovery to find out if they actually knew. And then you work on whatever claims are available based on actual knowledge that this person has committed misconduct in the past.
Well, again, I think there's a few portions of that question. As to the entitlement to discovery, the Arizona Supreme Court's been very clear that you have to prove or plead facts to get past the motion to dismiss stage. And we just don't have any facts about the misconduct supposedly committed by Father Hen here. And I would note, Your Honors, that after the Superior Court granted the dismissal of plaintiff's claims, plaintiff filed a motion for new trial, which was over 170 pages long and included a large number of documents that plaintiff contended were new evidence. Well, that evidence, first of all, was not new. It had all been in the possession of plaintiff's counsel well before the motion to dismiss briefing. It was more than 20 years old. And on top of that, what was revealed in that motion for new trial briefing in the Superior Court, and I would encourage the court to go back to that, specifically at Exhibits 2 and 5, were that the Salvatorians did not have any notice regarding Father Hen's purported misconduct until 1983, which is 3 years after plaintiff's alleged abuse, and they did not pass that information along to the diocese defendants until after that.
Counsel, let me ask you, I understand your responses to Chief Judge Catani's questions on paragraph 108, your view that it's a legal conclusion, it's a short piece. This is a 3C case, right? Sort of not against the direct alleged perpetrator, but and we're on 12b6 grounds, right? Fair state of claim upon which relief can be granted, meaning the paramount inquiry is the FAC viable, is it righteous or not? And you talked about 108, but let me ask you to address paragraph 91, where it seems to me that there are allegations about new or otherwise had actual notice of misconduct, including by Father Hen, and then there's some, in general categories, sort of alleged misconduct, factual misconduct listed there. And I don't think there was a motion for a more particularized statement, which I completely understand given the length of the FAC, but doesn't 91 allege some facts on that front?
I really don't think it does, Your Honor, because to the extent that it alleges any facts, First of all, it's I think very unclear, very vague, because it attempts to jam all of these different allegations together, and it's unclear who did what or when. And I'm not saying that they had to plead every aspect of who, what, when, where, why, and how, but nonetheless, when somebody attempts to mash all of these allegations together at once, it's entirely unclear what's actually being alleged here. And certainly I don't see anything in here that identifies any conduct by Father Hen prior to 1978. You could read it in a way that suggests that somebody somewhere within some aspect of the defendants, and again, there are two groups of defendants here, but whose employees, whose agents, and
It's a broad allegation, you're right, but it to me at least, it appears to allege some specific factual allegations. It names Father Hen included in that. We know, at least from the complaint, that Father Hen, in paragraph 82, the factual timeline for him that we care about, I think, is 1978 to 1982, pretty short period. The allegations of abuse in 105 are 78 to 80, so it's an even narrower point than that. But I struggle with 91, and that's a new paragraph added in the first amended complaint. 108 existed in the original complaint. So if you're helping me better understand that, but that one seemed pretty facty to me.
well, and even if it is more facty, which I continue to dispute, but even if it is, that one does not include any date. So I think we have to look at this particular allegation in the context of all of these other allegations, many of which, or I think almost all of which, post-date 1980. And so if you're reading 91 in context of 50 through 54 and a variety of these other allegations, 58, 59, these 60, these are all allegations about what occurred after 1980. And so whether the defendants knew or had actual notice of misconduct by Father Hen or somebody else within the defendants' organizations, and again, that's entirely unclear, we don't know the time period here. And the key under the window legislation is that it was notice of misconduct that gave rise to an unreasonable risk of sexual contact. Well, that has to be prior misconduct. It can't possibly be after the fact misconduct, because that wouldn't give rise to any risk.
Well, could it be contemporaneous also, prior or contemporaneous?
It could be contemporaneous, as long as it's before the last instance of abuse. I would agree with that, yes, Your Honor. But here we just don't have any factual allegations in that regard. And again,
Why is it not a factual allegation to say that they knew that Father Hen committed sexual misconduct before abusing the plaintiff? You have to specify exactly how they knew. Why is that a legal conclusion as opposed to a factual allegation? They have to say he had a criminal conviction prior. That do you have to point to all of the? Well, I'm just confused as to why that's necessarily a legal conclusion rather than simply a factual assertion.
So I don't think it's on the knowledge piece. I think it's on the misconduct piece. So to me, saying that he committed sexual misconduct is an incredibly vague and conclusory assertion of something, and we don't know what that something is. It's a bit akin to saying defendant negligently operated his vehicle. Well, you have to have some fact there to say what it is that happened. Defendant rear-ended me. Defendant ran the red light.
But
Something.
If you said there was
fact.
a rape, if you just substituted the word rape for sexual misconduct, that would be okay?
Well, I think it would, Your Honor, and I think this goes to an argument that we've raised in our briefing, which is that plaintiff's interpretation of both Rule 12 and the window legislation, I think, conflicts pretty significantly with other rules of civil procedure, including 1, 8, 9, 11, and 12, and 26 for that matter, because if you're alleging that Father Hen committed a rape before 1978, that is a fact. I don't dispute that at all. That would be sufficient. But there would have to be evidentiary support for that under Rule 11, and I think that's exactly what plaintiffs are trying to avoid here, is having to allege facts that they don't have evidentiary support for.
But we're at the allegation stage. We're not at any stage of proof where evidence needs to be presented to a trial of fact. I don't think anyone disputes the acts of sexual misconduct. The question is whether the diocese and the order knew or should have known. So I'm understanding you to say if they put on evidence of the actual misconduct, then everything will be fine, and I didn't think that really was the issue.
Yeah, I apologize, Your Honor, if I was unclear. So I think if I can clarify, Rule 11 certainly applies at the pleading stage, and so even when you're asserting allegations as opposed to evidentiary facts, you still have to have a good faith evidentiary support basis for that allegation. So I'm not suggesting that they have to prove their claims right now, but if, as the Arizona Supreme Court has said, they need to plead facts and they're unable to do so in the context of Rule 11, they shouldn't be allowed to continue just by saying defendants negligently harmed me, which is a legal conclusion. It's not a fact. And so the other point, I think, to your question was that it's not merely a matter of whether the defendants knew about something. It's a matter of whether they knew or had otherwise had actual notice of misconduct committed by one of these individuals, and the individual has to be the perpetrator. I don't think the statute makes any sense otherwise.
But the allegation says including Father Ham.
In paragraph 91?
Yeah.
Correct. It does say that, but again, I think that allegation is extremely unclear as to who's supposedly doing what and when. There's no date to that particular allegation whatsoever.
Well, and I guess I'm confused about, it sounds as if you're asking at the allegation stage that all the particulars have to be laid out as it would be at a more evidentiary portion of the proceeding than at the complaint stage.
I'm certainly not intending to do that, Your Honor. I agree that this is not the stage at which the plaintiff needs to prove anything at all, but they do need to allege some factual allegation.
Well, but what I take from your answer, though, I take it that proof isn't necessary at this stage, but you want the plaintiff to lay the case out in detail as if it were going to prove the case.
Again, Your Honor, that's not my intent. My intent here is to say that there has to be some factual allegation that is susceptible to proof. The idea that defendant committed some unclear misconduct at some point in time, or that one of their employees somewhere in the world at some point in time committed some misconduct, is a legal conclusion. It is not a factual allegation. There's no way to test that through discovery other than this incredibly broad sort of assertion that plaintiffs have made about every possible employee. We have to go explore what did that employee do.
But let's assume even if we're going to go with your interpretation that it has to be this employee. And let's say the personnel file has 10 incidences of sexual misconduct with a minor. You're saying the defendant can't bring a lawsuit unless they somehow have access or know what's in that personnel file, that you would acknowledge that the personnel file exists and that it has 10 incidences of misconduct prior to the alleged misconduct here. Are you saying you can't bring that file without knowing what's in the personnel file?
I will answer that, Your Honor. I see that my time's running short, so I do want to reserve some time for Mr. Fleischman. But to answer your question, Your Honor, let's remember that the window legislation does allow plaintiff to sue the abuser, him or herself. And so there's absolutely no reason, and in fact, plaintiff's counsel has sued Father Hen in other cases. There's absolutely no reason you can't sue the priest, subpoena the supposed employers or principals of that priest, get the personnel file, and then learn exactly what it is that you're trying to learn. The legislature has come up with this particular statute for reviving claims, and it talks about exactly when a claim may be brought. And so, again, Your Honors, if I could just conclude briefly and allow Mr. Fleischman some time. The sole issue raised by John N.D. Doe in this appeal was waived. The appeal can be rejected on that basis alone. If the court is inclined to reach the substance, again, the Superior Court was exactly correct. The plain language of the window legislation requires a plaintiff to plead facts, not legal conclusions, regarding defendant's knowledge of actual notice of prior misconduct by the alleged abuser himself, and the First Amendment complaint in this action was devoid of any such facts. Thank you very much, Your Honors.
Thank you. Counsel, the perils of going second. We'll give you 2 more minutes. How about that for a total of 3? And I'll give 2 more for rebuttal as well. But
Thank you so much, Your Honor. It was a surprise to see the clock as it was hidden.
time goes quickly.
Again, good morning, Your Honors. May it please the Court. Mitch Fleischman with Thorpe Schwar PC, along with my colleague Bill Thorpe on behalf of the Salvatorians. We join the arguments presented by Mr. Gray on behalf of the diocese parties. Given my time and given that Mr. Gray was quite comprehensive and presented well-stated arguments, I won't belabor this court with repetition. However, I do reemphasize the 2 distinct bases for this court denying the plaintiff's appeal. And I'd like to dedicate some of my limited time here to the first issue, which is that this appeal should be procedurally denied due to the court's lack of jurisdiction to hear an appeal premised on a theory of vicarious liability. I heard Mr. Abney assert that vicarious liability is alleged in the complaint, particularly at count 1, but my review again of the complaint identifies 4, not 5 counts. Count 4 is absent, so the last one is count 5.
And I fear I led us down a bad path on that.
But nonetheless, negligent. Count 1, negligence. Count 2, negligent training. Count 3, negligent retention. And the 4th count is negligent hiring. There is no vicarious. The word vicarious does not appear in the complaint. There's no theory of vicarious liability set forth. The word vicarious or vicarious liability does not appear in any briefing at the trial court level, in any oral argument, and plaintiff most certainly specifically identified the scope of this appeal as one as to whether the plaintiff may bring a vicarious liability claim. And that was not a gaffe. That is reemphasized in the 15 pages dedicated to it in the reply. With respect to the more substantive issue, I would only like to address paragraph 91. Those facts that were set forth seem to be based on this pervasive culture of abuse by bishops and priests. I see my time ran out. May I just conclude my sentence?
You may.
That paragraph is predicated on the overall theme of the complaint, which is a pervasive culture of abuse by priests or bishops in the church, and it alleges generalized types of misconduct and says including Father Hen. But in the opening brief, plaintiff at page 26 admits that the assignment to St. Mark was Father Hen's first assignment and that he was first ordained as a priest in May 1978. So the reality here is that there cannot be any existence of prior incidents of misconduct that predate the allegations here because he was not even ordained as a priest prior to that time. Thank you.
Thank you, counsel. Mr. Abney, rebuttal.
Thank you, Your Honor. I was going through the complaint, and I would note for the court that the initial paragraphs of the complaint specify that the defendants were acting through their bishops, priests, brothers, provincial employees, and agents. The structure of what's going on here under the statute is indeed a form of vicarious liability. Also, sometimes lose sight of exactly what happened at the trial court. The trial court declined to address arguments that no viable claims were directly made against the Salvadorians, for instance, because it was exclusively deciding this on the basis of the statute of limitations. And the reason the statute of limitations applied here and is extended to allow this particular lawsuit is because that there was knowledge of any misconduct. I know the court's been focusing on paragraph 91, and which is a good solid paragraph as far as knowledge about what Father Hen, whether he posed an unreasonable risk. But there are other paragraphs there that more specifically address these issues. Paragraph 112, for instance, talking about before the sexual abuse committed against John Indigo, that the defendant knew and had actual notice that Father Hen was not fit to work with children. There were similar allegations allegations about in paragraph 115 and 116. All these paragraphs have to be viewed as light most favorable to the plaintiff, and all reasonable inferences from the paragraphs have to be taken in the plaintiff's favor as well. So if they're not as artistically drafted as they should be, there is some leeway there because of that principle of interpretation when we're dealing with a motion to dismiss. The notion that the individual has to be the one about the any misconduct you need to know about doesn't fit with the language of subpart C. It's not what it says. It's talking about the any misconduct that is creating an unreasonable risk of sexual conduct or sexual contact. And that's what was happening in this particular case. There was that sort of environment at the time.
Well, counsel, but that goes back to my earlier question to you. It sounds as now you're arguing that there doesn't have to be any knowledge specific as to Father Hand. It's the general environment, and that's enough notice.
Yes, Your Honor, that's true. Although, when we talk about Father Hand, the defendants shy away from these direct statements in the complaint that there was knowledge about Father Hand in particular. But you're allowed to, you don't have to say that on such and such a date and such a time we do such and such a thing. You can be somewhat general about that when you're talking about knowledge and notice. I think it's Rule 9 talks about the fact that you could plead that sorts of things with some generality. But here, there was both generality and specificity about knowledge and notice that would be sufficient to support a cause of action. It's going to be a matter of proof. What's in the file? What are in the materials? What are in the investigative materials that the church may have that it hasn't revealed yet?
So, counsel, are you changing your initial answer to me, though, and saying that we don't need to reach the general environment knowledge issue because you're making specific allegations regarding knowledge of Father Hand's activity?
Yes, Your Honor. I'm sorry. I keep wandering out into the field of what's the wildflowers there. I'm sorry about that. Yes, we don't need to get into that. There are sufficient allegations that support liability here. I don't have anything else to say right now. If there's any questions, I'd be happy to address those.
Thank you. I've conferred with my colleagues. We have no further questions at this time. Counsel, thank you. Thank you for your written briefs. Thank you for a presentation today. You've given us much to think about. We will take the matter under advisement. We'll issue a written ruling in due course. The court stands in recess. Two of us are going to stay on the bench while we set the courtroom up for a next oral argument. One of us will leave and we'll have a new judge come. Court is in recess.
Thank you, Your Honor.